Thanks for having me. Ms. Douglas said, I'm with the Saline County Public Defender's Office. So the one part of this uh, class that we're going to do, I deal with every day. We're going to talk about sealing records, what it takes to do it, how to go about it. And you got to forgive me. I'm going to pretend like I know a lot of y'all have been attorneys way longer than me, but I'm going to pretend like you have never heard of record sealing before. We're going to start very basic, so forgive me for that in advance for those of you that probably know more about this than I do. But we're going to start from the beginning, and there's two kinds. There's the record sealing that everybody thinks about when you get your record sealed or a person gets their record sealed after being found guilty of an offense. Then it dawns on them and they realize that they need to get that sealed. It is always better to get that done beforehand, get that done as a result of your plea. Um, so let's see here. We're going to share this screen with you here. So like I was saying, it's always better to do it beforehand, have it a condition of your plea uh, to get your record sealed. So there's two ways you can do that. The first way and the best way is Act 346, which you hear referred to as the First Offenders Act. And there are the statutes. And I believe she is going to email this slideshow out. If she doesn't, you're more than welcome to email me, pgann@salinecounty.org. I'll be glad to share it with you. But the First Offenders Act, there's the statutes that govern Act 346. And then two, Act 531, it's great. It's not quite as good. We're going to go over what they all do for you, the qualifications to get those. It's also referred to as the Community Punishment Act. For those of you in criminal defense that work out arrangements or have clients that are sentenced to ACC or RPF, Act 531 basically established ACC. So I should have put these in the opposite order because we're actually going to talk about Act 531 first. As a public defender, I don't do very much with sealing records after the fact, but I quite often have to deal with these two pre-adjudication matters. I'm always trying to get my client, get it off their record as soon as I can, if that is possible. So what does Act 531 do for your client? Well, it's basically the same thing as getting your record sealed after the fact does. It seals their criminal record. Now, it does not eliminate their criminal record. Their criminal record is not destroyed and done away with, but it seals it from view. And the main benefit that this gives them is when they're looking for employment or maybe housing, if you're filling out an application for housing in an apartment complex or something like that, and they do a background check, it allows them to answer no when they are asked that question. Have you ever been found guilty of or pled guilty to or no contest to a felony offense? It allows them to answer no to that, and it should not come back on a background check when those people run it. Now, there are some professions that if they apply for, it will not seal the record from. Okay, this is for jobs and apartments, but if you apply for a job, say in law enforcement or the medical field or education, those are the big three, they will likely always see it. Those fields of employment are a little more sensitive, and 531 will not seal it from those. All right. So the first thing that you look at on our 531 is it a target offense? Now, the statutes there that list the target offenses, this list came straight from the statute. And you'll notice, you've got your basic things on there. Now, typically, the charges for Act 531 are going to be non-violent and non-sexual offenses. Now, there is a way to get some violent offenses sealed, but not through Act 531. You're going to have to do that after the fact because there's going to be statutory waiting periods on those. All right, but you see your basic your basic stuff on here. You notice that DWI down here on the left-hand column, second from the end, that DWI fourth or subsequent offense is eligible for Act 531. Now, I put that good luck in bold because these are, Act 531 and 346 are pursuant to a plea agreement with the court. Good luck getting a prosecutor to allow you to plead to Act 531 on a felony DWI offense. And if you do somehow pull off a miracle and get the prosecutor to agree to that, good luck getting the judge to agree to it. I do not. Now, I practice in Saline County. I'm in front of the same judges all the time. I don't know how it is in the other counties. That's one negative of being with the public defender's office. All my experience, all my knowledge of judges are just here. I don't think that would go over very well here. I don't know about where you're at. Most, in the right column, most B, C, and Ds are eligible as long as they're not violent and not sexual. So controlled substance felonies are typically available for Act 531, but not trafficking. If it's trafficking, you're not going to get that. Unclassified felonies, as long as the sentence range doesn't exceed the B felony limit. Now, this is something fairly recent. I know with the possession of fentanyl statutes, some of those are unclassified. And I know trafficking fentanyl, if y'all are in the criminal area, y'all have seen that. I've got a case right now, and it's a minimum 25, maximum 60 or life on an unclassified fentanyl felony. So if you run into those, obviously you're not going to be able to use this. Now, misdemeanors, most misdemeanors will qualify as long as they do not require registration on the sex offender registry and that are not DWIs. All right. So you look here, this is what you must successfully complete this. Your client will have to be pled to probation, ADC with judicial transfer to ACC, or commitment to the county jail. One of those three things has to be a part of their plea. Now, notice that ADC says it's with judicial transfer to ACC. So they have, a 90-day ACC commitment or commitment to RPF. Those are okay. ACC and RPF are okay. But if they plead to actual ADC time and spend actual ADC time, they wouldn't be available for 531. So for 531, 346, that's a First Offenders Act. You can't have any prior felony convictions. With 531, you can have one, okay? No more than one prior felony. That prior felony cannot be for the list that's there. And of course, it's the most serious of the offenses that we deal with. Most of those are either Y felonies or A felonies. So long as they only have one prior, and that one prior is not one of those offenses, then they could qualify for 531 where they would not qualify for 346. Things to remember about Act 531. One question you get a lot is about firearms rights. We are in the South. This is an important topic for a lot of people here. Act 531 does not restore Second Amendment rights. You are still convicted of a felony under 531. Now, there are a few ways that Second Amendment rights could be restored, but 531 is not one of them. The main ones that pop up are pardons from the governor. 346 does restore them, and there are also some drug court. If somebody completes drug court and has their record expunged that way, that it will restore those. And the reason for that is with drug court, they don't enter a sentencing order until, once drug court is completed, the case is dismissed. So you did not get a guilty in the first place. So 531 is not going to affect the loss of Second Amendment rights, and you are still a felon. All right, so that is the basics for 531, and I was going to stop and see if anyone had any questions about 531 before we moved on to 346. And I see, can we do, from Ms. Wilson, can we do a 531 on an aggravated assault D felony? So let me scroll down here for something real quick to check something. So for violent D felonies, aggravated assault would be a D. We're going to talk once we get done with 346 and 531 about aggravated assault. They can be sealed. There is a statutory period that you have to wait before you can get a violent D felony sealed. So you can seal an aggravated assault potentially, but not through Act 531. So yes, it can be done, but not through Act 531. All right. So for pardons, doesn't the pardon have to specifically restore Second Amendment rights? I have not done a pardon before. I know there are two things. There's more than one thing that a pardon can cover, and there's a couple different ways the governor can do it. And yes, it has to specifically restore Second Amendment rights. Law enforcement, education, and one other could see the 531. The medical field has some benefits and some rights to see stuff sometimes. As far as your background, even after something's been sealed. The other one would be the medical profession. Is felon in possession of a firearm a violent D felony? I do not think possession by itself. Now look, y'all, if somebody knows better than I do, I do not claim to know everything. Correct me if I'm wrong. I do not believe a D felony, felon in possession, is listed as is considered a violent felony. It's not on the target list. I don't know that that list is particularly exhaustive, though. Would you say that it's faster for our clients to seal a misdemeanor to do Act 531 versus just sealing it on the back end once the sentence is complete? I've never done a 531 on a misdemeanor. I know it gives you in the statute, it gives you that possibility. Misdemeanors are typically fairly easy to seal as long as they're not one of the ones we'll talk about later, DWIs, violent ones, ones that require sex offender registration. As long as they're not something like that, misdemeanors are typically pretty easy. And typically on a misdemeanor, with it, as y'all know, for everything you say, there's 10 pages of exceptions for it. But typically on a misdemeanor, it's pretty easy to seal when your fines are paid and the case is going. Could someone get Act 346, then dismiss and seal? Could then get 531 twice. All right, so we're going to talk about that at the end of when we talk about 346. We're going to talk about what it still applies to and what it doesn't still apply to, and I think that will clarify that part. We got a question: can you get a judge to agree if the prosecutor does not? So I've never tried that, so I do not know the answer to it. I think it would be, judging from what I see in the courtroom, would be unlikely. So I know with 346, it has to be pursuant to a plea. 531s typically do too. I've not heard of them not being pursuant to a plea. And around here, the judge just isn't going to mess with the pleas. If the sentence and everything seems fair, they don't get involved in our pleas, which I'm very thankful for. So, but long story short, could you? I don't know the answer to that. I think it would not be very likely. So, Scammo 346 counts prior for our further one. Yeah, we're going to get into that, and I think that is accurate. They can still use it for calculating priors and stuff like that. Joshua Ide, you can use 531 without having it in the plea in the state. Thank you, sir. That is good to know. So apparently, without having it in the plea, the judges, Megan, some judges will give 346 over the state's objection. I'm glad to hear that. I've not seen it, but I'm very glad to know that some of them are thoughtful enough and compassionate enough to do that for their clients. All right, so let's talk about what a 346 does for your client. And 346, like I mentioned before, it is the definitely the better of the two because of that first thing there. There's no finding of guilt. So the judge does not do a finding of guilt, and when they say it, they most of the time here, but I've said they don't even say I find you guilty of such and such. They say I'll accept your plea and sentence you pursuant to the agreement under Act 346. They try not to even use that word. Upon completion of the probationary period, the case is then dismissed. Now, the thing about Act 346 is it's one and done. You get one bite at that apple, and that's it. It's the First Offenders Act. You cannot use Act 346 more than one. Now, a common question that I've heard asked a few times is, every state, most states probably have some First Offender Act statute. They have a method or a mechanism by which somebody can get a deferred adjudication on their first felony. So the thing that the question that you hear, if they have availed themselves of that in a different state, can they then come to Arkansas and take advantage of the Act 346 in Arkansas? There is some case law on that. It doesn't look like I wrote it on here, so I'm going to type it while you're. Montoya v. State dealt with this exact issue. It was a deferred adjudication proceeding in New Mexico, and the person did our equivalent of Act 346, and they were dismissed with prejudice once they completed their court-ordered obligations and probation and fines. Came to Arkansas, and the Circuit Court said that he could not avail himself of 346 in Arkansas because he had gotten the equivalent somewhere else, and it was overruled. It was so look up that case, and it'll you can see the details on that. So there is some case law that if someone has used this in a different state, that it could still be available in the state of Arkansas. So that's good news. But 346 is a one-time deal. Now, 346 can be used for felonies and misdemeanors, but this is something, and I might have this opinion because I'm a public defender and I may or may not be a little jaded, but as a public defender, a lot of my clients are repeat clients. Okay, I've seen the same. I've been a public defender for 3 years, and there's people I've seen 4 or 5 times already. I am hesitant to recommend that my client plead to Act 346 for a misdemeanor for those reasons. Now, you may know your client better. You may not have any qualms about doing that. I'm a little hesitant on misdemeanors because misdemeanors are easy enough to seal anyway, post-conviction, and I don't like wasting that 346 on a misdemeanor. Maybe I'm thinking completely wrong about that. I don't know, but I'm hesitant to do it. So 346 must be the result of a plea. No-low pleas are fine. You can plead no contest and still agree to enact 346. Per the statute, you cannot get the benefit of 346 if it is a result of a trial, whether it's a bench trial or a jury trial. It has to be negotiated at the plea. And like I said, what Ms. Wilson let us know, I'm very glad. She said Judge Watley and Judge Johnson will give person a 346 if they're eligible, even if it's over the state's objection. I wish that were the case here. And, I've never really asked for it. That might be something to think about, and it's great to know that some judges will do that. But if it's a result of a bench trial or jury trial, the statute says it's not available. So there are a lot of offenses that are not eligible for Act 346 listed in those statutes. Most of them are ones that you would expect. I don't think anybody's going to look at this list and be surprised that that these are on the list. This is the most serious uh, of offenses. Now, at the bottom it says any serious felony involving violence as provided in 54501. The list down here, of course, any murder. Kidnapping is the Y felony. You know, there's also a lesser offense for kidnapping. If, like, I think one of them is if the person's released safely, then it's not a Y. But the Y one is not eligible. Um, the Y felony version of terroristic act or ag assault on a LEO, not eligible. Now, there are also some offenses that specifically list in the statute that they are not eligible for Act 346 or for the records, the Uniform Record Sealing Act. The only example that I know of now, I didn't have enough time to look through all this, the whole code book and see which one of them did it, but I know there's one. Possession of a firearm on school property specifically lists in that statute that a person found guilty of this is not eligible for that record sealing. So the list is not exhaustive because some of the statutes, expressly prohibit it right there in the statute. So there's requirements. They must be sentenced to one of the following on a 346 plea: minimum 1 year of probation. Same thing we had before, ADC with judicial transfer to ACC. ADC sentence doesn't qualify, or county jail. So probation, ACC, or county jail. Fine can't be greater than $3,500. Now, when a person gets placed on and most of the time it's going to be probation. If a person gets placed on probation under Act 346, and then that person subsequently has a petition filed to revoke their probation, if the judge does in fact revoke their probation, the judge may issue an adjudication of guilt on that case and proceed just like he would have before. The 346 is gone, and they've already pled guilty. Now, it says may issue. He doesn't have to do that, but the judge does have the option of entering a adjudication of guilt, and you have that then that's on their record, and like I said, that is if they violate their probation. And it's probably going to be what I would think here for that to happen. If it was a technical violation, if somebody missed a meeting or two, perhaps had one failed drug test or something like that, they probably wouldn't. If they go out and get new offenses while they're on probation, you can probably kiss that 346 goodbye. So there's work requirements listed in the statutes. I don't ever see this come up. I have never saw this be an issue on an Act 346, but the statute does require that they work in a suitable environment for the condition during the probation, either for 3 years or to the end of the probation, whichever's earlier. It actually gives the judge the leeway, the authority to order a defendant to enroll in school or a similar program if they don't have any marketable employable skills. Again, I learned this when I was reading over the statutes to talk to you about this today. I've never heard it mentioned in court. So here's the good and the bad. So during the period of probation, if they're put on probation, and I have seen what I've seen in Saline County is they're going to make the probation period, the prosecutors, a little longer than normal if they agree to a 346. So you're probably going to be in Saline looking at 4 to 6 years probation, probably, if it's a D. And during that period of probation, the defendant is considered as not being a felon except for these things. So that firearm possession, that right that it's restored through 346, while they're on probation, they are barred from owning firearms. So also, even though the person pled under 346, they can still use that when calculating habitual offender status. So if your client has something sealed under 346 and then they pick up another felony, the next felony, both of those are going to count. They're going to count to that small habitual offender status. When they're determining a criminal history score, when the prosecutor is looking at that to see where they fall on the sentencing grid, it can still be used for that. Obviously, sentencing. If you, and this could be a couple of different things. If it's a probation revocation or something like that, they can use that to tell the judge as part of your criminal history. And if you are at the end of a jury trial, if somebody's been found guilty of something, then they can show the jury those priors, even if you pled under 346. Now, and obviously the last one, none of this surprises anything. Just about everything can be used for impeachment purposes. So that is during the period of probation. Okay. Now, once the probation is over, basically it's the same list, except this is Arkansas. We're in the South, so you get to have guns again. So, but all those other conditions are still the same. They can still use it to calculate your criminal history score. They can still use it to charge your client. Still use it to charge your client under the habitual offender status. Of course, it can always be used for impeachment because just about anything can. And of course, if you're in a jury trial, when they're arguing sentencing to the jury, they can show them that as well. But once it's over and there's the statute there that particularly does that exact thing. So do we have any questions? I've got C1 about 346. Have you seen in Saline, Ms. Wilson said, have you seen in Saline an early termination of probation with Act 346? I have not with 346. Now, that's that I know of. I do not, I mean, most of the time, I'm not asked about that. I'm not really privy to it. I know that, you know, once a person served half of their probation, I know if their fines and fees are paid, they've completed all their other court-ordered obligations, have not done anything to violate their probation, they can apply for early release of probation. I know they can do that. I have not heard of one being terminated early on a 346. Can you seal arrest? Yes, you can, and we're going to talk about that in just a minute with the post-conviction sealing stuff. And Ms. Cross said early termination of probation is always an option. People just don't know about it and don't ask. That is always an option, and I always tell my clients that when they get placed on probation. I give them the rundown and let them know once they've served half of it, you know, that they can apply for early release. Now, I believe, I don't know exactly how that works. I think the prosecutor would have an opportunity to object to that. And if it's not a violent crime, you know, maybe they wouldn't. I know here they haven't objected on just, you know, simple possession cases and stuff like that. If the judge requires a sentencing order on a 346 plea, does that constitute a conviction? I've never heard of that happening. So I don't know the answer because I've never heard of that happening. If a sentencing order is done on a 346, it should not be filed with the court, I wouldn't think, unless the person, you know, did something to violate their probation and get that taken away. But I've never heard of a judge requiring a sentencing order on a 346 plea. And maybe I just haven't looked close enough at that and need to look at that. Do it in Benton County all the time, especially if there isn't a no contact order in place. Yeah, that would make them hesitant, I'm sure, but I'm glad to hear that judges are letting that happen. Is probation always supervised under 346? So here in Saline, felony probation is almost always going to be supervised anyway. Now, I know most of the people for nonviolent stuff are, once they do good for a while, are placed on monthly reporting where they're not actually, you know, having to go in every week or every 2 weeks even. They're on monthly reporting. Ms. Sawyer, how is the 346 probation shown in a background check, if at all? Now, this is just, I think I know the answer to that, but don't quote me on this. If you're meaning during the period of probation, on a background check, I always assume that I know you shouldn't do that. You know what they say about that. but that it would show as a pending case. Now, I do not know if that is. Uniform sentencing order has boxes of check for 346 that make it clear there's no finding of guilt. Yeah, thank you. Seen someone be federally indicted for felon in possession even after a 346 successful completion of probation. Wasn't sealed correctly after the completion and showed up on NCIC. Thankfully, the feds eventually dismissed. Yeah, that is, I've not heard about that case, but let's see, so they had a 346 on a possession of firearms by certain persons. It was dismissed, and then yeah. So what? Yeah, and there are several different agencies that stuff gets sent out to when a record is sealed, and yeah, sometimes people mess up and don't enter things correctly, and that's bad luck for our clients for sure. Sentencing orders are done on the 13th. Okay, so a lot of this stuff I might be running together. I handle the drug court for Saline County as well. And I know in drug court, they don't enter anything. And with a 346, it looks like they're going to enter a sentencing order, but they have that box to check that make it clear there's no finding of guilt. Can you seal a closed guardianship case in probate court? I have no earthly idea. I have never done anything of that sort. My entire career has been spent in criminal defense. So I do not know the answer to that. And we got a room full of people here. So if anybody knows the answer, give that to Miss Henry. Let's see, make sure I have not missed any questions. Don't think I have. All right. So that covers that's the two ways that you can do things beforehand, which it's always a good idea to get out in front of that. But after the fact, there are ways that you can do it. Let's see, these statutes. Yeah, I would think, and like I said, I've never done any DHS cases. I would think a lot of that stuff would be sealed or redacted anyway, and not just open to the public. Maybe I'm wrong about that. Still appearing in Court Connect. How do you get that removed? Is that a responsibility of the clerk's office? Yeah, you should be. I mean, one of the instructions, and you can read that in the statutes that I posted up at the top about those acts, is it talks about instructing certain people to seal it, and so. All right, so let's talk about post-conviction. There's the statute range that talks about the procedure for sealing the records. Now, I put a hyperlink in here. All these petitions and orders, you can print them out at this email, at this URL here. Now, there with sealing post-conviction, there are several different ones. Some of them are made specific. Like for felonies, Act 1460, you see that one. There is a separate form if you were trying to seal an arrest where there was no charge filed, but the arrest still pops up on your record. There's a separate form to seal that. There's a separate one for drug offenses, a separate one for DWIs. Again, good luck. But they have several different ones. So when you're trying to seal a misdemeanor post-conviction, you can file immediately after completion of the sentence for most misdemeanors. There has to be a full, oh my goodness, I sent this in with a typo, a full patent of fines and court costs. Sorry about that. And I still messed it up. But fines and court costs have to be paid in full. Full payment of driver's license reinstatement fees. A lot of drug charges come with 6 months driver's license suspension. That's a statutory thing. Driving on suspended, stuff that gets you suspended. You have to have full payment of your reinstatement fees and completion of your driver's license reinstatement requirements. And that's normally all that you need to do as far as sealing most misdemeanors. So with misdemeanors, there's no limit to the number of misdemeanors that you can seal, but these crimes here have a look back period. You have to wait 5 years after the completion of the sentence for negligent homicide, battery third, domestic battery, the icky stuff. So for a DWI, it doesn't have the 5-year look back. In 565-111, it says must wait until the look back period is over. Now, for misdemeanor DWIs, the look back period is 10 years now. Now, I was talking to a coworker who actually did a lot of work actually drafting these statutes. So I was bouncing stuff off of him to make sure I wasn't going to get up here and tell y'all something wrong. And he was telling me about, for some of these, he did a petition to seal. I don't remember which court it was in, and he's practiced all over, so it may not have been, it probably wasn't even Saline. But he did one, and at the time of the DWI, the look back period was 5 years at the time of the offense. And he said, now it's 10 years. So if somebody gets a DWI today, it's going to be 10 years after the completion of the sentence before they can get it sealed. But he actually got one sealed sooner than 10 because at the time of that person's offense, the look back period was 5 years. So there's a lot of talk about that. And, at the end of the day, this stuff is discretionary for the judge. This is going to be left up to his view on things. So that one, he was able to do that. Be a huge fight one day because of the once you get to felony level, that look back period goes to 20. For the B, so if someone has a DWI, one DWI, I don't see a prosecutor objecting. But if they have multiple, prosecutors, they're going to think about things, through their lens of what they consider common sense to be. And if you had one DWI 8 years ago, they might not object, or 10 years since your last one, and they may not object. If you had one and more than one, they're probably going to be less likely to do that. So another thing you can't seal misdemeanors if defendant had a CDL, if it was a part of that traffic stop. Prosecutor has 30 days to object when you file a petition to seal. If they don't object, the judge can just enter an order sealing the record. On a misdemeanor, he can do that. He can enter an order sealing it if there's no objection. If they do object, you can get a hearing and let the judge make the call. So when you seal felonies post-conviction, nonviolent C's and D's, you can do immediately after the completion of the sentence. Of course, the exception, the look-back period. When you get to felonies, like we said, it can double. For violent C's and D's, we had a question earlier about sealing an aggravated assault, Class D. There's going to be 5 years after the completion of the sentence, not more than one prior. Now, when we say not more than one prior, when we're talking about 531 and this post-conviction sealing, if it was part of the same episode, 2/3 of my case files, they're charged with more than one offense in that same case number and through that same course of conduct. So for purposes of sealing, if multiple felonies are committed in this one course of conduct, they're treated as one conviction. So now, the fact that prior felony, if you had a prior that was sealed, that does not prevent it from counting for the purposes of the current petition. All right. Offenses not eligible to be sealed, even after post-conviction. Y's and A's and B's are typically not eligible for sealing, except possession stuff. If you have an A or B felony simple possession, it is eligible, but of course your trafficking stuff is not going to be able to. Manslaughters, unclassifieds where the max sentence is more than 10. And of course, we all know that felony sex offenses and violent offenses are not going to be able to seal. Felony traffic offenses if the offender has a CDL. I can't think of any felony traffic offenses. I would think if you were to the point where you were getting felony DWIs, you probably wouldn't have a CDL anyway. I mean, so I'm not sure. And maybe that's like if they get pulled over and have a possession case while they're driving. But yeah, the DWIs, it should not get to that point with a CDL. Now, before we had a question that said, can you seal an arrest? And yes, you can. There is a specific form. If you go to that link where I did the post-conviction, the first slide, that link will have all of these forms. One is for an arrest. So you wait a year after the arrest. If charges have not been filed, then you have the right to petition for that to be sealed. If it was null-prossed by the prosecutor, you can seal it after 1 year. Reason for that, and I'm mainly talking to our guests that are not in the criminal area. If the prosecutor null-prosses the case, technically they can bring that back up to a year. So there's kind of a look-back period on that almost. They don't call it that. But if they null-pross it after 1 year passes, you can petition to have that sealed as well. A case where there was an acquittal. Now, we had a question up earlier when it was talking about Act 3s or mental disease or defect. If there was an acquittal due to mental disease or defect, it mentions in the statute that is, one of the things you can petition for an acquittal unless it was due to mental disease or defect. What is the reason you can seal a conviction but not an arrest that led to that? I don't know that that's accurate. I think you could, I don't know why you couldn't do both. And if you seal the conviction, I don't think that's the case. And if it is and somebody knows better, like I said, I don't claim I know everything. If somebody knows better, let us know. But I don't think you would have a problem sealing the arrest that led to the conviction. So procedure to file post-conviction sealing, you must file a petition, obviously in the jurisdiction where the person was convicted in. There used to be a $50 filing fee for filing the petition to seal your record. In July of 2019, they did away with that, thankfully. I know a lot of my clients, money's an issue, or they would be one of y'all's clients. So there's no filing fee as of July 2019. Obviously, serve the prosecutor within 3 days of filing. They can file a notice of opposition within 30 days. Now, remember I said earlier with misdemeanors, if the prosecutor does not object, then the judge has the discretion to just seal it without anything further. If an objection is filed, the court will set a hearing, or the prosecutor in a felony may consent for the judge to rule on the pleadings. Now, if the prosecutor does not object, the last thing on there, the court can only grant a felony petition after a hearing is held. So they can just say, oh, they didn't object and file it on a misdemeanor. They're not supposed to do that on a felony, and I've heard of it happening before. Good job if you've got a judge to do that, but they're not supposed to do it. They're only supposed to grant a felony petition after a hearing. But the prosecutor can, he can consent for the judge to rule on the pleadings. If you seal something post-conviction, most of these are what we talked about with 346. But sealing it, what it does and does not do. Sealing the record doesn't, determining of offender status, habitual offender, impeachment. And here's where that, I was telling you earlier, healthcare professional licensure, they're still going to see it. That doesn't do anything there. Certification, eligibility, or ability to act as law enforcement officer, things like that. If you wanted to join the military, obviously that's not going to hide anything from them. So that is the things that it doesn't do, and obviously it does not. Post-conviction sealing has nothing to do with Second Amendment rights. You're not going to, it's going to take more than that to get that back. So that is all that I had. Do we have any other questions that I can answer for you? And if I can't, maybe, I mean, there's over 100 lawyers in here. Somebody can. All right. Concealed cases be used to enhance future crimes committed by a defendant. Let's go back up to that. Enhancement of future crimes. Well, it's going to let them look at your criminal history score. They're going to be able to use it for sentencing, for habitual offender status. I do not recall seeing anything particularly in the statute regarding enhancement. My guess would be that they could. If anybody knows better, let us know. Any changes or law updates from this legislative session? I've not heard any as it relates to sealing. Felony charges sealing. How years have to wait to be able to seal felony charges? So if they're nonviolent C's and D's, you can petition to seal them immediately after the completion of the sentence. If they're violent, then you have to wait a while. But remember, on sealing them, it is not the offense date that you're going 5 years from. It is the date of the completion of all the obligations that the court set forward. Are there any step-by-step flyers to distribute in the community? I know Arkansas Legal Aid had some. There was a page on there, or Arkansas Legal Services Partnership used to have a page on there that broke it down and gave you something, so you probably can find something like that there. Yeah, we addressed the gun rights one. Only the 346 does that. Can you seal an arrest? We talked about that. Can a court sua sponte seal a record? So I do not, that is a question I did not anticipate, and I do not know if they could do that of their own motion. Haven't heard of it and don't know. How broad should the scope? There we go. How broad should the scope of sealing be from a client perspective? These cases appear in so many places, it's difficult to catch and cover all of them. How broad should the scope of sealing be from a client perspective? Clarify that. What exactly are you? These cases appear in so many places, it's difficult to catch and cover all of them. What are people likely to screw up when they're attempting to do this? If somebody's doing it themselves, what are they most likely to screw up? Just the service aspect, the scheduling of the hearing. Um, that's what is likely to catch the lawyer off guard. Well, some of them, like on sign to seal a violent, you don't have access to their history. And to seal a violent felony, you can only have one prior. And one thing that, prosecutors have that handy dandy ACIC computer in their office that we are obviously can't be trusted enough to have access to. So we don't have their criminal history in front of us. So that's one of the things that could catch you off guard. Let's see. Have you ever sealed records under the Veterans Treatment Court statute? I have not. Arkansas have any laws in place that out-of-state data systems cannot show sealed convictions and/or arrests? Wrong guy to ask for that. Don't know if I don't think there's any. I don't know that we could. I just don't know. I was trying to think of a better way to say it, but I don't know the answer to that. Felon in possession of a firearm is a violent if it's classified as a D. I don't believe it is. Matter of fact, I'm almost certain it's not. What's the general time frame to process the record sealing under the various acts? So the time frame, the prosecutor is gonna have that 30-day window to respond. Um, I haven't done many I did a few post convictions before when I did some private work, and it did. I think now these were misdemeanors. I don't know that I did a felony post conviction, but it was. I mean, it was done really. There was no objection from the prosecutor, and the judge signed off on them. I think you would within a few months. I would think 346 is supposed to be automatic if successful completion of probation. Right? Yes. And what I do there is on that website with ACIC that lists all the forms. The 346 form is on there. And what I do when my client pleads under 346, I already have that order filled out. And as soon as he gets done going through their plea agreement with them, I hand him the 346 order and they sign it right there. So it's put in their file, and upon completion of probation, they file the 346 orders. I go ahead and I get that filed the day that they plead. I've been told that sealing doesn't help at all with immigration. Act 346 means nothing to them. I don't do immigration either, Victoria, but that would not surprise me in today's climate that they would not really care. Have attorneys seen as the What have attorneys seen as the benefit to using 531 on C and Ds that can now be sealed upon completion of a sentence? Now, it's not necessary. The thing is, sealing a felony conviction is going to be the discretion of the judge. Obviously, they don't have to do it. You're not entitled to have your record sealed after the fact. I think if you use Act 531 on those felonies at first, there's not going to be any balking at the end. There's not going to be any, the judge is probably not going to use that discretion. He's probably going to, well, they were under Act 531, here it is. I think they would think less about it. So I think having it on the front end on a 531 is the way to go. Thank you all for the kind comments that you're putting on there. Have you ever seen immigration arrests on your ACI report or any of your systems? I don't have access to any of those ACI reports. The prosecutors normally type out a list of what their priors were for me. Ms. Wilson had someone deported within 3 days on a plea of guilty to hinder an apprehension first offense. Yeah, they are. Immigrants should not plead guilty, but instead NOLO. Yeah, I don't know if that would help or not. It would. I mean, it obviously looks better than a plea of guilty, but even with a NOLO plea, there's still a finding of guilty. It doesn't change that part. All right, I think that is all of the questions. Thank you very much, guys. I appreciate y'all being here and listening to me ramble on. Y'all got to hear my first ever CLE, so hopefully I made a little bit of sense and didn't ramble the whole time.
No, this is really great. Thank you, Paul.
Thank you.